Please get ready for a dictation of exercise number 27 from legal material. 5 seconds. Start. Such an invalid report may still fall in any case cognizance so taken is only in the nature of error in a proceeding antecedent to the trial. If therefore cognizance is in fact taken on a police report vitiated by the breach of a mandatory provision relating to investigation, there can be no doubt that the result of the trial which follows it cannot be set aside unless the illegality in the investigation can be shown to have brought about a miscarriage of justice. Assuming that the police report based upon facts discovered during such an investigation cannot form the basis for taking cognizance. For the reasons stated above, the petitioners must face trial for the offence. However, since no offence under section 341 of IPC is made out from the allegations made against them, their trial under that section cannot be allowed to continue. The proceedings pending against the petitioners are therefore quashed to the extent they pertain to offence under section 341 of IPC. The proceedings will, however, continue for the offence thereof. The disputes between the parties pertained to the claims of the objector for load violation charges, misuse charges, and low power factor levied on the basis of an inspection conducted on 7/9/1989 in the premises of the petitioner, which is the registered consumer of the electricity connection. By the impugned award, the arbitrator has disallowed the claims based on each of the three aforesaid charges. The first issue pertains to the claim for misuse charges. The objector alleged misuse of the electricity connection on account of the fact that the electricity connection, which was sanctioned in the name of the petitioner, was being used by one Messrs. Delta Electronics Private Limited. As per the contention of the objector, this amounted to misuse and therefore misuse charges were payable. The arbitrator has held that misuse charges are not payable for the reasons: 1. The company Messrs. Delta Electronics Private Limited was found to be a sister concern of the petitioner registered consumer, and which sister concern was under the same management and which had around 99% common shareholding. 2. The arbitrator held that there is no definition of misuse in the relevant tariff rules, and consequently the ordinary meaning of misuse as applicable in a relationship between a landlord and a tenant should be looked into, and which, when done, shows that there is no subletting. It has been thirdly held that the arbitrator by referring to the agreement that the user of electricity by a sister concern does not amount to transfer or parting with possession of the electricity connection. All the above reasons are perfectly valid, and I do not find that the objections by the objector with regard to sustaining of its claim for misuse charges are at all justified. The arbitrator has arrived at a finding of fact after referring to the returns filed by both the companies before the registrar of companies and also with reference to the provisions of Companies Act. Both the companies are sister concerns and alter egos of each other. The facts of the present case are not such that there is subletting of electricity from one company to another company or from one entity to another entity, which are wholly unrelated to each other, in the sense that one is a complete stranger to the other. Stop.